Mr. Castellara.
My Lord, before the short adjournment, I said that there were 4 reasons that permission to appeal should be refused on ground 4. I'm going to revise that down to 3. And that means that when the Lord Ladyship's looking at my skeleton argument, it's not necessary to consider, in respect of ground 4, paragraph 62.
Let me just check I've got the right skeleton and can identify the paragraph. So that's the 3rd?
Yes.
Yes, I follow.
And I just set out, in advance of getting into my now 3 submissions, the basis on which I said the second appeal test applies, which means I can get on to, I want to say the substance, but it's the meat. I propose to address your Lord and Ladyships on the tests that I say therefore apply, taking them in turn by reference to the aptly named uphill, tab 11 of the authorities manual. The facts are at paragraphs 5 and 8. The Deputy District Judge granted a without notice extension of time for service of claim form, and the District Judge, following hearing, refused to set aside that order. At paragraph 12, the Circuit Judge upheld that refusal on appeal. At paragraph 14, this court stated that it determined the relevant issues in previous cases as truly. At paragraph 18 is the relevant part of the judgment. It was held that test A could only be satisfied where the point in issue had not already been established. So looking at from H on page 112, that has not yet been established in the 3rd line. And then over the page from A, where the issue sought to be raised concerns the correct application of a principle whose meaning and scope have already been determined, it does not satisfy test A. And my Lord will remember that 5213 is where it was before the amendments that moved the second appeals test to 52.7. Here the appellant is clear that the point was established in Norton. So if I'm right about 52.7, permission cannot be granted under test A. The court in Uphill went on to look at test B. At 19, it's Lord Justice Dyson giving a judgment of the court, said in the 3rd line, compelling is a very strong word, emphasises the truly exceptional nature of the jurisdiction. 2 lines down, second appeals are exceptional. We looked at the Tanfern's case proposition. And then the relevant parts are in paragraph 24, subparagraph 1. Very high prospects of success will almost always be necessary, but will rarely be sufficient. That's what 24.1 says, in a nutshell. 24.2 has 2 propositions in it. The first is that a complaint that a judge did not find for a party because she failed to raise a point before him will not amount to a compelling reason.
Sorry, where do I see that?
Yes, from G. If it is the appellant's fault, first
I see, yes.
And then at H, there's the exception. There might be a compelling reason if a decision that postdates the judge's decision shows it to be wrong. In my respectful submission, we're in the general rule rather than the exception territory for 2 reasons. First, this is not a case in which the judge was asked to consider a point that subsequent authority has shown he dealt with incorrectly, so that he was wrong and his error should be rectified. you'll note that the passages that help with that are 26 and 28. Second reason we're in general rule territory is that this is not a case in which this court revealed something in Norton that could not have been discovered by reading the statute. I want to take you very briefly to the statute, page 9 of the authorities bundle. Three subsections I need to take you to. How do we get here? 1937AA ceased to be subject to the duty having informed the appellant in writing of the matters mentioned in subsection 7AB, subsection 7AB(c), the effect under 195A of a further application to a local housing authority within 2 years of acceptance of the offer. And then turning to 195A on page 15, what does it provide? Provides two things. Subsection 1, an applicant who accepts a PRSO and reapplies within 2 years needn't show that she has a priority need. That's the dog leg under subsection 1B. Neither is normally followed by nor, but I need to say and. 1A, when read with 2, alters the rule as to what it means to be homeless. Lady Justice Elizabeth Lang dealt with this in Norton in a single paragraph. It's tab 32.
Sorry, just wait for me a moment because I seem to have lost one of the authorities' files. Sorry, yes.
Tab 32, my lady. Paragraph 43. Ground A raises a very short issue of statutory construction. The question is, what is the effect of section 193(7)A(b)(c) within 2 years of the current application? The introductory words of 195A2 are for the purposes of subsection 1. Subsection 2 is a special rule for the purpose of subsection 1 about the time at which a person becomes homeless. In my judgment, the words in section 193(7)A(b)(c) include the effect of subsection 2. That's it. Lord Justice Mayles gives a concurrent judgment with which my Lady Justice Asplin agrees, in which he says at paragraph 56, it wasn't explained, it should have been. That may have an important effect. This was not a case in which a new avenue of challenge was opened. Indeed, in this case, excuse me, let me start that sentence again. This was not a case in which a new avenue of challenge was opened. Miss Uduezue could have run this point just as easily as Mr. Norton, whether on review or in the county court. And indeed, Mr. Norton did run the point on review. That's 32 Roman numeral 4.
It escaped your clients.
Not the only person in this case.
No, but you say, well, it's all very obvious, but no one.
Can I stress this nuance? It may or may not be obvious, but the question to this court is whether there's a compelling reason to grant permission. There may be cases in which this court overrules the decision of the High Court. That might give a compelling reason, but this is not that case. In this case, it's not a new avenue of challenge. That's really what I want to focus on. It's not in fact, there is a remedy. that some court has previously said there wasn't. It's just there. I read the statute. This is what it says. I should say that if I'm wrong that the second appeals test applies, my now 2 remaining submissions apply in any event. The second reason that permission to appeal should be refused is that the ground was not raised before the judge, and the authority would be put to considerable disadvantage were it to be considered for the first time on a second appeal to this court. With an eye to the time, it's Sin at tab 22. Facts, paragraph 8, money claim, statute barred. Paragraphs 11 and 12, Lord Justice Lewison grants permission to appeal on a ground that wasn't raised below, and explicitly reserves the right to argue that means it shouldn't be dealt with. The relevant passages of the judgment are 16 to 18. Cautious when allowing new point to be raised in an appeal not raised before the first instance court. The appellate court will not generally permit a new point to be raised if, and I'm interested in both of these, it would necessitate new evidence, or it would have resulted in the trial below being conducted differently with regards to the evidence. That's where it's point of fact. And in paragraph 18, even where the point might be considered a pure point of law, the appellate court will only allow to raise the 3 criteria satisfied. I don't make a point about A because of what Lord Justice Underhill said in his order listing this to be heard together with the substantive appeal. B, I do raise. The other party has not acted to his detriment on the faith of the earlier omission to raise it, and C is there, maybe for another time. Your Lord and Ladyship have seen that the appellant's reasons for refusal had nothing to do with the private rented nature of the offer, nor with its relative impermanence compared with, say, a Part 6 offer. Her only concerns related to the location of the property per se. So it is at least possible, and I'd like to say likely, that informing her of the effect of 195A2 would have made no material difference. But that is important because the court retains a discretion to refuse to grant relief, even if a ground of appeal is made out. I need to look at 2 cases for that, as briefly as it's possible to do so. The first is Degnan at tab 9. Degnan at tab 9. Substantive judgment of Lord Justice Old starts at page 725. Unfortunately, the paragraphs aren't numbered. In the first paragraph, he makes it clear that the issue was whether the underlying accommodation was suitable. There's reference to 65.2 of the 85 Act. That is 1932 in the 96 Act. And there's reference to 69.1, that is 2061. Next paragraph, there's a citation in inverted commas. That is the reason, those are the reasons that the accommodation was offered was refused. And the one that's material is kitchen, third line of kitchen, open plan, fourth line of kitchen, extremely dangerous. Over the page, in the first substantive paragraph, that fourth line, there was a non-statutory appeal procedure. The authority dismissed the appeal. And in the last sentence of that same paragraph, the chairman of the council committee responsible for the decision made a note on the document recording the decision, issue about open plan kitchen to be considered by surveyor. Next paragraph, the council informed Miss Degnan of its dismissal of her appeal, but didn't mention the chairman's note. Next paragraph, the pre-action letter, its first few lines, first 5 lines, made no reference to any concern about the kitchen. And then just moving down about 3 or 4 more lines, the sentence that starts, in it she mentioned. Nothing about the kitchen. 2 months later, leave to move to judicial review. Notice of motion contained 2 complaints. No mention of the kitchen. Her affidavit in support of the application was to like effect. Over the page again, second substantive paragraph under Mr. Justice Hidden. The substantive application came on for hearing. Mr. Gallivan abandoned the 2 grounds of application and replaced those 2 grounds with a kitchen-based ground. Next paragraph, her second affidavit was the first time she made direct reference to the kitchen in the claim, and indeed the first time she'd done so since her refusal of the offer. Over the page, first paragraph, the judge found that the decision of the council was unlawful. Why was it unlawful? One looks at the citation under that paragraph, last 5 lines. It seems to me the decision is communicated to the applicant did not follow the form of the decision made by the committee. Therefore, the communicated decision may be said to have been a decision which failed to have regard to what was acknowledged in the note of the decision to be a material factor. He then, following on, went on to refuse relief as a matter of discretion. He did so because, in his view, even if the direction about the kitchen had been communicated, so great was Miss Degnan's concern about the other matters that she would still have refused the offer. What is that saying? The judge refused relief because, in his view, on the evidence, even had reference been made to the kitchen, the offer would still have been refused. The consequence, paragraph below, 4th line, she would still have refused the offer. And then over the page, first substantive paragraph, I interpolate there to suggest that the judge was in fact saying he should only refuse relief in the exercise of his discretion if the unlawfulness of the decision made no difference to the outcome. That's the proposition. So Degnan is recognition that if the unlawfulness of the decision would have made no difference to the outcome, the judge is entitled to decide not to quash it. We've already looked at Ali, but I said I needed to come back to it for a different point, and again I'll do so briefly as I can. It's tab 10. Passages I haven't taken you to. Paragraph 3, the judge found procedural irregularities underlying the offer. That's the first 3 lines. And then going down to the line that starts department, which is slightly more than halfway through paragraph 3. Nonetheless, he decided the decision of the respondent inevitably being the same, even if they followed a fair procedure. 10 and 11, over the page, the judge was right, the court was right to identify those irregularities. And 13, Party King. It is accepted that in a situation such as this, the county court should only confirm a decision otherwise vitiated by procedural irregularity, if it can properly be said the decision would inevitably have been the same, even had the matter been dealt with. What then is my submission? Had ground 4 been raised below, the authority is likely to have explored by evidence the question whether or not referring to 195A2 would have made any difference to the outcome, or whether the outcome would inevitably have been the same. Not having had that opportunity, caution precludes the grant of permission to appeal. I'm not advancing my 3rd reason. My 4th reason is that there is no explanation for the 84-day delay between Cramp being handed down and this application.
Norton.
Norton.
Well, yes, did I say Cramp?
Yes.
Norton. Cramp is 2012.
It's a 4-day delay.
84-day delay between Norton being decided and this application being made. And 2 final sentences, and then I'll hope not to outstay my welcome. Mr. Hodgson said that permission should be granted because otherwise, and he suggests that the ground should succeed, because otherwise the appellant would be prejudiced because she would have had the duty to her discharged following an unlawful approach. I want to explore that. The offer was made on the 11th of August 2020. It was a 1-year AST. Any section 195A2 point lost all its relevance in August 2022. In practice, it's wholly unclear what prejudice the appellant might have suffered. If I'm wrong about all of that, and permission to appeal should be granted.
Sorry, can I just
Yes.
think that one through? Perhaps just say it again so I can think it through properly.
Mr. Hodgson says there's prejudice.
Yes.
Prejudice that he says exists is that the duty to the appellant would have been discharged unlawfully. I say that prejudice is difficult to understand in circumstances in which she's had longer in accommodation than she would have been expected to have under a 1-year AST. And more importantly, the 195A2 point has died by the passage of time.
So, just to understand that, just suppose that the applicant had accepted the offer and she'd had the 1-year AST. What would have happened at the end of it?
At the end of the 1-year AST?
Yes.
One of a number of things. It would have rolled on as a statutory periodic tenancy. It would have been brought to an end by statutory grounds after service of Section 8 notice. It would have been brought to an end by Section 21 notice. Both of those require execution of the possession order. The difference with the latter, Section 21, is that had she received the Section 21 notice, that expired, she could have attended at the local authority's offices.
So suppose she'd accepted the AST and the Section 21 notice had been served, then as you say, she could have come back to the local authority and said, you've got to house me again.
Yes.
And if alternatively she'd just stayed there, she would have had continuing accommodation. Now what happens now? Should you win this appeal, what happens?
The review decision is upheld. The consequence is that there's no duty, and practically, Mr. Hodgson having adduced this evidence in his skeleton argument, Ms. Uduezue makes a further application for homelessness assistance on the basis that she has a 4th child.
But you don't accept you have a duty to her anymore?
No, we don't have a duty to her. If this court upholds the judge's decision that the review decision must not be quashed, there's no duty under the existing application, nor indeed can she come back in under 195A2.
So why is that not prejudice? Because if she had accepted the offer, at worst, she would have been evicted and had a right to come back to you. As it is, she has no rights.
Right, except that my point would be better made had 4 years of it, because that's the latest point at which a Section 21 notice after 2 years could have been brought. But the prejudice that Mr. Hodgson suggests is that she'll be without accommodation. She's been with accommodation after the local authority decided that she wasn't owed it for 2.5 years. I don't say it's a reason that permission to appeal should be refused. I say it takes the sting out of his prejudice argument. That's as high as I'm putting it. Incidentally, Mr. Hodgson says that I say, paragraph 63 of my skeleton argument, that Norton should be distinguished. I make no such submission.
Yeah.
What I have said, at paragraphs 64 to 65, is is that even if I'm wrong about all of that, and you grant my motion, you should refuse the ground on the substance. I don't need to rehearse that. It suffers the difficulties that I acknowledge in my skeleton argument itself.
I mean, if you got that far on the authorities, you'd have to show inevitability, I suppose.
I'd have to show inevitability.
Whereas you say you don't need to show inevitability. It's enough that you would have been able to argue inevitability had the point been raised earlier.
Precisely, which is why I don't want to.
Yes.
Unless I can assist, those are my submissions.
Thank you very much.
So before my learned friend Mr. Burton rises, I did want to point out the court the permission to appeal in Zaman of Lord Justice Arnold, page 198 in the core bundle in that case, because it's clear that he's applying a test in relation to all grounds of satisfying both limbs of a second appeal test. It would be unfortunate if different Lord Justices of this court were applying different tests.
It may turn out that that is what's happening, Mr. Grundy.
My learned friend obviously didn't know about that order, so because it was in our core bundle, and I looked at it after he'd made his submission, and after I heard your proposition, my lord.
Mr. Bassett.
My lord, my ladies, I'm going to take, if I may, ground 1A, little b, and ground C effectively together. I'm sure you know what those are, but first it's a question of law. Was there a legal obligation to try and locate accommodation as close as possible in Zone C? And then ground C, 1C, non-compliance with the acquisition policy. I agree with my Lady Justice Asplin about where the battleground is in this case. Why was nothing made available for the appellant in Zone C? That was closer than Stoke, conveniently referred to herein as the Midlands. This issue was raised in terms by Camden Law Centre in its representations, and indeed by the applicant herself in her email of the 23rd of July, the day after the offer, where she said, "I am surprised that the proposed location of my new home is about 150 miles away. What efforts were made by Waltham Forest to secure accommodation nearer to Walthamstow?" Equally, the reviewing officer acknowledged that that point was directly an issue in the review decision, paragraphs 126, and makes specific reference to Ms. Zaman's question at paragraph 154. It was also ground 1 below. It's obviously ground 1 here before you. You don't need to concern yourself with any alleged evolution or change in the grounds. Ground 1A, little b, do you have to look for accommodation as close as possible in Zone C? As I understand it, the respondent's proposition appears to be that the statement in paragraph 19 of Enzalamiso, as it concerns the outer borough duty, as we've called it, viz. Must generally and where possible try to place a household as close as possible to where they were previously living, no longer applies or is qualified in a specific way, that it applies only insofar as ties at the previous accommodation can be maintained. My learned friend makes that argument of law in order to make good the following proposition, that it is effectively sufficient to discharge the duty to say that the respondent tried to get you in borough, Zone A, we tried to get you as close as possible to the borough, Zone B, but because that failed, we can now effectively send you anywhere in Zone C because your links to your previous accommodation are, by definition, broken. We say that's an important issue, irrespective of its materiality to the particular case before you. We've seen a number of cases where local authorities use similar zonings, 1, 2, or 3, or A, B, and C, albeit this precise issue hasn't come up because none of those cases concerned an offer in Zone C or its equivalent. My learned friend gets to that legal proposition by 2 routes. Route 1, reliance on the 2012 suitability order. You may recall in his submissions he drew you to Article 2B, which is the one which requires local authorities to consider disruption to various links, social type links. In our submission, that can be no basis for the legal proposition. Indeed, it's hopeless, not least because the 2012 order was explicitly considered in Enzalamiso by Baroness Hale. And in any event, as was pointed out by my Lord or Justice Newey, it rather ignores Article 2A, which requires consideration of the distance of the property in a freestanding sense, not in a way which is contingent upon the level of disruption or indeed anything which is said in Article 2B. The second point that my learned friend relies on is the change in guidance post Enzo Lamiso. 2 points to make about that. First point is the focus of his submission isn't the part of the guidance you'd expect. The material part of the guidance is the second part of paragraph 1750. I wonder if we could just look at that very briefly. That's in your authorities bundle. Looking at the guidance. Page 49. Keeping in mind what the submission is here, that the outer borough duty is contingent upon disruption, my learned friend doesn't focus on the second paragraph of 1750, sorry, second sentence, or indeed the third, but instead focuses on the new part of the final sentence in paragraph 1749. So my learned friend's submission is, well, in Enzo Lamiso, the guidance was different. It didn't contain the second part of the final sentence of 1749. That is true. I'll come back to that in a moment. But really importantly, in Enzo Lamiso, paragraph 1750 was effectively exactly the same. And therefore, insofar as that might have provided some basis for his legal proposition, it cannot be right because it was considered by the Supreme Court. As regards the second part of the sentence to the final sentence 1749, which I accept is new and post Enzo Lamiso, well, of course it is. Its purpose is to try and incorporate the very guidance that Baroness Hale gave in Enzo Lamiso to local authorities as to how they might go about demonstrating compliance with the very duty we're concerned with. So to suggest that introducing that second half of that sentence in some way altered the duty itself is, with respect, an unfounded legal proposition. So for those reasons, we say the position as set out in paragraph 19 of Enzo Lamiso remains the law and should be applied as such. And there's no basis for concluding that there was no obligation to find accommodation as close as possible within Zone C as a question of law. Just in passing, we would suggest that the potential conflict between 1749 and 1750, if it does exist, can be resolved this way. Accommodation will be suitable despite ostensibly nearer accommodation being available because a fair and reasonable allocation policy has earmarked the closer property to somebody else, even in a notional sense.
Can you just give me that again? Accommodation will be
suitable despite ostensibly nearer accommodation being available because a fair and reasonable allocation policy has earmarked the closer property to somebody else. That somebody else, of course, may be a notional somebody else or a hypothetical somebody else, but it's somebody with higher priority. Because when you come back to read Enzo Lamiso, you'll see that the purpose of the allocation policy is to identify on what basis scarce accommodation will be distributed between people who are otherwise entitled to the benefit of these duties.
Does that quite make sense? I mean, if it's been allocated to someone else that's not available anyway.
I think it's to address this scenario, that when you're looking at a particular state of supply, it's not open for a person to simply come along and say, well, I can see you've got accommodation notionally available, which is nearer. By definition, that's mine now, by application of the in-borough or out-of-borough duty. What Enzo Lamiso established is, well, hold on, reasonable practicability, or whichever way you want to assess a test, can be looked at in this way. It's legitimate for a local authority to say, yeah, but we do need that for other people we know are going to be coming. We've anticipated demand, and they're going to have all sorts of reasons why they've got a higher priority for that closer accommodation than you. And that's perfectly legitimate. We accept that. That's how we understand the introduction of policy in 1749 to work. That's the caveat to what is otherwise a fairly blanket categorical assertion that if there is accommodation nearer, then you ought to get it.
I'm not sure how long it's worth spending on this, but does that really fit the new wording? It's all the accommodation has been offered in accordance with the published policy.
Yes, well, I appreciate perhaps, one might say that the reference to has been offered suggests past tense, but I'm not really sure that makes very much difference to the general point that the guidance is trying to suggest here, which is you can have policies, as is established in the prior paragraph, including an allocation policy, and it needs to somehow establish in the guidance why it might be appropriate for a local authority to say, we're going to hold back some properties. So whether or not, if it had been offered, it's not likely to be available. So the scenario envisaged in the first part of that paragraph doesn't arise.
But you're sort of saying it's about the possibility you might want to offer them to someone else, whereas arguably what it's talking about is offering to this particular applicant.
But the problem I have with this is then the contrast is between is available. So it says where accommodation which is otherwise suitable and affordable is available has to be contrasted with has been offered to somebody else. I suppose a particular property could be both simultaneously available and offered to somebody else. That does seem to me to create a comprehension problem, which I must confess I hadn't perceived beforehand.
Yes.
Or another way of putting it, perhaps I can make better sense of it this way, is that if the offer that has been made to you is the product of a fair and reasonable allocation policy, which has not offered you something which is ostensibly otherwise available, then it will still be suitable despite that other property being available.
I think that's how I understood it.
Yeah, I think that's probably
closer,
better.
I think, to Mr. Grundy's submission.
Yeah.
So that is, so to speak, some kind of qualification to the start of 1750.
Yes, but it's one, absolutely, but it's one which exists in the judgment and ends in any event. And it's one, for avoidance of any doubt, isn't remotely contested in these proceedings. We absolutely accept that that scenario can happen. And indeed, we've seen it operate in the case law in scenarios where it's incontrovertible that the person doesn't have, pursuant to the allocation scheme, an entitlement to a closer property, but nevertheless argues a breach of duty. And unsurprisingly, those cases don't get very far. But perhaps the most important feature on the facts of this case is that just doesn't carry over here, because it's never been the respondent's case that scarcity or anything to do with the appellant's comparable level of priority or need is the reason why nothing closer in Zone C was offered to the appellant. That really is the key feature of this case. And the fact that the local authority doesn't rely on apparent scarcity in that area might be thought to be a very unpromising start to its ability to show that it's not possible to find somewhere in the Midlands, no matter how hard it's required to try and find it. This is not a case of hard-pressed authorities struggling to meet the demands of individuals who bring appeals before you. This is not a case which engages the principle of judicialisation of welfare benefits. The reference for that is Lord Justice Lewis in Alakabet, paragraph 37, where he explains what judicialisation is about. It's about the court inadvertently stepping into that balancing exercise and giving it to one and not to another. We're not in that territory in this case. So the real question is, has the local authority shown that it tried to secure accommodation as close as possible to Waltham Forest, i.e. in the Midlands? Quick propositions in relation to that. It's a matter for the LA to discharge the local authority that obligation. And whatever the content of it is, it must mean something in terms of what efforts must be undertaken to look. We know that merely having a policy is not enough. And we know that from Enza Lemiso, paragraph 42, and Alakabet, paragraph 48. The court needs to be able to decide the question by reference to the review decision combined with the published policy. We say in order to do that in this case, the local authority needs to engage with a specific question. Did it look in the closest conurbations outside the areas in which it assessed supply to be constrained? That is the Midlands, the next conurbation after London, and nearby boroughs. In other words, that's the real factual question. That's the battleground. So what do we have to demonstrate that the respondent did look there or had some good reasons why it didn't? The acquisitions policy, the paragraphs I took you to are the same ones that my learned friend took you to. Certainly stipulate that this should have happened. There should have been a search in those areas. It doesn't, as a point of fact, provide any detail about how that would have happened, unlike other policies. And of course, as I've already pointed out, it doesn't say there is any problem of supply in such areas. And in any event, the critical question, as it was in Abdelkader, is, did this happen? This is the way it was put in paragraph 59 in that case. If in fact Ealing had followed its own policy, that would have been, all that would have been required would have been a statement saying that it had and explaining how it had done that. And this is where, in this case, one finds the evidential black hole. Nothing at all in the review decision. It appears the review officer didn't think she actually had to address that issue at all, paragraph 141. My learned friend relies on the witness statement that Ms. Batt prepared after she received the appellant's skeleton argument. We don't object to that, but we just invite the court to treat it with some caution. Reference for that is Ermakov, tab 8, paragraph 85.
Well, the point also is that in that statement, and it was Miss Batt who wrote the review decision.
It was indeed, my lady.
It appears there was after the review decision that she then made inquiries of another colleague as to what inquiries had been made in other areas.
Absolutely, my lady. Absolutely. And even then, the evidence, such as it is very weak. Giving it its most generous reading, like my learned friend invites the court to do, it suggests that she did look, that the searches were not restricted to certain areas, which one then could mean they searched in the Midlands. But she merely states that the respondent does look in those areas, not that it did. And there's certainly no explanation of how it did that. That's the critical point, as per Lewis in paragraph 59. And just to point out, as an important difference, at least in Abdelkader, the policy did say, in terms how the searches were carried out. We don't have that in this case. It would have been very simple, just as it would have been in that case, for the local authority to provide a statement saying this is actually what we did to look in those areas, and there isn't one. Mr. Grundy expressed concern that this court was being invited to presume that no searches were carried out adequate to meet the policy and or the legal test. We say the better analysis is that he is inviting the court to presume that compliance did take place, irrespective of the surprising outcome. Indeed, all Mr. Bernardi and Mrs. Zaman were doing were querying that surprising outcome. Finally, on this point...
Just before you move on,
yes.
Remind me, where it was the Zone B counties?
They are listed in the policy itself.
Yes.
The allocation policy. Let's give you the page.
I'm trying to come up with an example in Zone C, but just outside Zone B.
I see, sorry, the ones that we gave were the Midlands ones that I mentioned in my opening, including places like Birmingham, obviously, Luton, etc. Is that what my lord's asking about?
Which county is Luton in?
It is just outside Hertfordshire.
It is just outside Hertfordshire.
Yeah, so the zones are on page 7 of your supplemental bundle.
Thank you very much. So suppose that your client had been offered a property in Luton.
Yeah.
But otherwise everything had been exactly the same.
Yeah.
Could you have complained?
Well, that's again focusing on just the outcome without looking at the method. But if Luton is as close as possible as you can get in Zone C to Zone B, then it's highly unlikely there's going to be any scope for complaint, because there's no reason to infer a failure to search in whatever distance exists between Luton and the borders of Zone B.
And I suppose that's what I'm getting at. Does there have to be something on your case giving rise to a reason to infer that there has been or might have been a failure to search for something closer?
I wouldn't say it's a prerequisite, because if you take Abdelkader as an example, the appellant in that case was given a property right on the border of the borough, which incidentally is why we say Lord Justice Lewison expressed regret about having to allow the appeal. And his complaint was, well, there wasn't enough evidence that any searches had been done in borough. in a borough, incidentally, where the evidence was, unlike this case, clear that there was a real shortage of supply. So I don't believe we have to start from a factual presumption in order to invoke the positive obligation on the local authority. It applies each and every case where compliance with the duty is raised. What I would say is this, that where you are looking at a surprising outcome, or one like this, where major conurbations don't appear to be the subject of a search, or at least, maybe put it another way, the distance of the accommodation is very far from the appellant's previous home, then that does raise significant questions and may indeed require the court to require a greater level of evidence to satisfy the court that the standard of reasonable practicability, or in the context of the outer borough duty, where possible, has indeed been met. If I put that slightly clumsily, but I hope you see what I mean. There may be a relationship between those two scenarios. Of course, we are dealing here with a property which is many miles away, and exactly the sort of mischief, potentially, that the order and the guidance are supposed to address. Was it really necessary to accommodate Miss Zaman so far away? But the final point about all of this is, insofar as there's any doubt about whether or not the duty was complied with, Mr. Bernardi, on behalf of Cameron Law Centre, said in his submissions, in terms, I can't find any evidence that you complied with your own policy, paragraphs 6.0, which includes paragraph 6.2, which says, for agreeing to the use of a specific unit, officers in the service are responsible for ensuring A, that the relevant acquisitions process has been followed, and B, that the acquisition of the unit is consistent with the principles of the acquisitions policy as set out above. And there is no evidence of that compliance at all. And that, of course, would have given the reviewing officer the assurance she needed, had she been alive to the point, and indeed Camden Law Centre, the assurance they needed that proper searches of the Midlands had been carried out. And despite the surprising outcome, there was no ground for believing the duty hadn't been complied with. And again, just to make the obvious point, that would have been so easy for the local authority to do if such approval had indeed been carried out. The risk, of course, for this court is if this offer is approved as being lawful, it will essentially be based on an assumption that the local authority looked in the closest conurbations to the sufficient standard and not on any evidence that it did. And that is exactly what the change in the legal landscape identified by Baroness Hale was intended to prevent, and is exactly what Lord Justice Lewison was vigilant to uphold in Abtecladir, and of course we invite this court to do the same. I can take the remaining points very quickly. How much time have I got? Ground 1AB, reasonable time. The principle that reasonable time may be a logical component of the duty, we say is untouched by the decisions in Abtecladir and Broderick. No argument in either of those cases that simply because the duty wasn't explicitly set out in the guidance or indeed in the statute meant that it didn't apply. What both cases do, and freely accept this, is express doubt as to whether or not a successful challenge based on a failure to consider reasonable time would be successful. And as we didn't look at this in my submissions because the case wasn't before you at that stage, in Broderick, that's paragraph 42. Where my Lord Justice Newey says, I would think, however, that it would be relatively rare for an authority's decision to make an offer on a particular day rather than to delay to be susceptible to a successful challenge, especially where, as was the case in Appellant, a shortage of housing is the constant backcloth against which all housing decisions are made. In a more normal case, it will not be possible to say that the authority has acted outside its discretion. Freely accept that, but of course this is the first time this issue has cropped up where there isn't such a shortage of supply. So there is a consistency of approach, we say, between those two decisions. It's unlikely to be available on the facts. This case is the diametric opposite of those cases on the facts. As for the question of practical problems which were raised by my learned friend and identified in the Broderick decision at paragraph 44, they concern a different scenario, which is where the appellants in that case were arguing what should have happened is that after an offer had been made, suitability should have been judged over 4 or 5 days to see whether further offers might be made after the initial offer. But in any event, well, that's what we're saying, I should just be absolutely clear, is that you should only consider discharging far away once you are satisfied that you've looked for somewhere closer for a reasonable period of time. That's a relevant consideration, and that's how it's put, paragraph 75 in Al-Kabir. And as for the contention that this would cause innumerable problems, the difficulty for the respondent is paragraph 3.3 of its own policy, which says in terms, bring it up, (3.3), which is at page 7, where it is not reasonably practical to offer a property in Zone A within a reasonable time, having regard to the demand and supply of housing and any cost to the council maintaining the household in temporary accommodation, a property in Zone B or Zone C may be offered. So to include that in your own policy as it concerns in-borough duties would suggest it doesn't pose or bring up insurmountable practical problems. And we'd say that's consistent with common sense. But it's particularly material where there isn't the pressing demand on properties. It also has factual resonance in this case for the 2 reasons we've identified, that for no apparent reason, no accommodation was offered to the appellant after October 2020 when the duty was accepted. And, well, I've already made the other point, that there was not a problem of supply in that area. So we say that was a material consideration, and the failure to consider it impugns the decision. Ground 1.2 is the point about affordability in relation to 2-bed properties. We say that there is a process point here. There is a clear policy, paragraph 3.6, to consider smaller properties in order to, quote, make best use of stock. In this case, the respondent considered themselves driven to locate the appellant miles away because she couldn't afford a 3-bedroom property. That was the factual nexus, and my learned friend says that this was an entirely realistic approach. But therefore, with that prospect hanging over both the local authority and the appellant, we say the local authority was obliged to raise the possibility with her of accepting a smaller property if it meant she could be placed somewhere closer to her former home. And again, we asked the question, how difficult would that be? On the 21st of July 2021, when she was interviewed by the officer, why wasn't that question simply asked? In accordance with the policy. If they knew otherwise, the risk was the appellant was going to be sent many miles away, which on the local authority's own case would be disruptive and difficult, even if not to the degree that would render it unsuitable. So we say that again was a material consideration, and the failure to consider it undermines the decision. Finally, on ground 2, first point is there can be no serious dispute that the reviewing officer was obliged to consider suitability, even if it wasn't raised. It's a matter of law. Lord Justice Lewison, paragraph 53 in Abdullah. And indeed, of course, the reviewing officer did consider suitability, as confirmed in her witness statement. We agree that the scope of the inquiries in relation to the affordability assessment may depend to some extent on what matters were either A, obvious to the reviewing officer, and that's cramped paragraph 13, or concerned entirely new areas of inquiry, or exclusively in the mind of the applicant. Abdullah, paragraph 54. But obviously in this case, the fact that the appellant would have to travel to London in order to see family and friends, and may have reduced childcare costs whilst in London because of her support network, were obvious because the reviewing officer herself relies on them in her witness statement, paragraph 47, and indeed purports to justify her decision on the basis that she could travel to see friends and family in London. So in these circumstances, in order for this appeal ground to fail, my learned friend needs to persuade this court the reviewing officer was freed of the responsibility as a matter of law and policy, it being set out in the local authority's policy that they will consider future costs in relation to offers of accommodation, to carry out an objective assessment of affordability, which took into account the cost of matters that the local authority itself has prayed in aid in support of its decision. We say that's an untenable proposition. Only the reviewing officer ought to have considered the additional costs of travel and indeed childcare when making a decision. Paley is an interesting example. Analytically, we would suggest, because in that case, one particular factor which was only raised on appeal and had never been raised before was contact with the father. And Lady Justice King, on the basis of the authorities I've just referred to, decided that was not a matter that could be the subject of a ground of appeal. Conversely, the appellant was allowed to challenge the rationality and the conclusion on the affordability assessment, even though in the review process she had not raised any challenge to the figures included therein. We say that's effectively this scenario. It's clear that the appellant raised the problems of maintaining her support network if required to move to Stoke, and it's clear the reviewing officer understood that. It's clear the reviewing officer addressed that concern by saying that she could travel to see them back in London, and it's also clear that she failed to therefore consider a relevant consideration on the affordability assessment. That's just a straightforward, ordinary public law failure. On the question of the implications of that failure, we don't accept that it's inevitable that the costs of childcare and indeed travel would not have meant this property was unaffordable. That's a high test. We don't have the information before us, and this court should be very slow to conclude that the decision would inevitably be the same. It's quintessentially the sort of matter that a local authority should be obliged to go and consider properly, so one can reach an informed decision upon it, particularly when one keeps in mind the serious implications of a discharge of duty decision for a family in a household such as the appellant's. My lord, my ladies, unless I can assist further on any of those points, or there's any discrete issues I can help with.
Thank you very much, Mr. President. Ms. Hobson.
My lord, my ladies, your lordship raised yesterday the question of consent. I need not take you to the document, but at page 41 in the supplementary bundle is a consent form, which I'm told was signed by the appellant and forwarded on the 2nd of September 2020. As a matter of practice, a similar consent form would usually be required once an applicant has applied for housing assistance. The reason for the second in this case is because the actual review decision was determined by an officer employed by the London Borough of Stoke, not Bexley. Okay. The gravamen of the complaint on the ground 1 is that the authority has equated eligibility under its allocations policy under Part 6 with suitability of accommodation under Part 7. And notwithstanding my learned friend's attachment to Crampton Hastings, for various reasons I say it doesn't apply, in fact, to any of the grounds. Firstly, on ground 1, as I said yesterday, the appellant was only aware of the existence of small accommodation when she received the review decision, which of course is already far too late. She can hardly be criticised for not raising it before. And indeed, the operative point is the date of the offer, extending it slightly to the date of discharge, because they were accepting representations from to that point. Secondly, of course, as you referred to authorities yesterday by my learned friend to my left, there is a positive duty to secure accommodation in boroughs so far as reasonably practical. So that is a matter that the local authority has to do regardless of representations made by the applicant. The authority for that is firstly PRSO, which you'll find at tab 16, page 188, and the authority that you're taken to yesterday, Beer, paragraph 53, tab 21, 637. The complaint is not, with respect to my learned friend, he's complaining that the applicant hasn't done the impossible. She hasn't said why the accommodation that wasn't offered to her would have been suitable. Of course, she doesn't know. There's no, all she knows is that there was two-bedroom property available. We're simply saying that the only reason that's been given, and therefore must be the reason why the two-bedroom properties were not offered, was because of we say, the mistake of equating eligibility with suitability. And again, we're not saying that the two-bedroom properties would have been suitable. The complaint is they should have been considered. Likewise, ground 2, again, Cramp and Hastings doesn't apply because there's a positive duty to make inquiries to safeguard, promote the welfare of children, including their emotional health. So representations, no doubt, are very helpful, but Cramp and Hastings doesn't apply there either. And of course, representations were made by the appellant. And where one is dealing with, well, as I said yesterday, in any case, each child is unique, each family's circumstance is unique, and the duty is to make what inquiries the local authority considers appropriate. In this case, one is dealing with a child who's been in insecure accommodation for years. Sole point of anchor has been the school she's been at. It's said that she has strong ties with her friends at the school. She's academically gifted, approaching important exams, and is expressing distress to her mother at the thought of leaving school and leaving the location. At the very least, I say, an inquiry should be made of the school. They would be best placed to say what the consequences would be if you were to have to move. Ground 3, again, Cramp and Hastings doesn't apply. The reason it doesn't apply is because this is a matter of statutory construction. Either I'm right or I'm wrong. Any representations by the appellant is neither here nor there. I say, of course, I'm right. There must be an offer from a private landlord to the applicant. But I apologise if our skeleton is not clear, but we say it should be the landlord should be identifiable to the applicant. Because if there's an offer is going to be made, one would usually expect you need to know who the offeror is. And again, usually one would expect that there would be the local authority say, well, Mr. or Mrs. or it company is prepared to offer you this property, and this is the standard agreement. In respect to ground 4, I submit that the second appeal test doesn't apply where the judge granting permission hasn't limited permission. So in the Haddock case, it is distinguishable because there the judge considering the permission to appeal expressly adjourned consideration of ground 2 to the full court. I submit that this court has the usual powers of case management to allow an amendment, subject of course to the usual hurdles which I would have to surpass. As to which, I say, what possible disadvantage can there be to the local authority, because the point of law is conceded. This was a defective offer letter. And the authorities that my friend has taken you to, where the court's held, well, it would have made no difference because the outcome would be inevitable, are all unlawful decisions.
Sorry.
They're all decisions which were held to be unlawful, but it would have made no difference. Norton is not an unlawful, is not dealing with an unlawful decision. It's dealing with a statutory requirement. And again, I say the local authority either complies with what the law requires it to do, or it doesn't. There's no room for saying if they don't, it would make no difference. And your lordship and your ladyship have the prejudice point on board.
So just trying to narrow down the key point there. That probably is the key distinction, isn't it?
Yeah.
You say it really doesn't matter whether the result would inevitably have been the same, could have been the same, whatever. Mr. Calzavara says the contrary. If Mr. Calzavara is right, then one can understand how the local authority might be said to be prejudiced by the point arising so late. If you're right, the local authority can't be prejudiced because nothing they could have said at a lower court could have helped them.
Well, absolutely. And there's no question of, one wouldn't normally expect there to be evidence in the homelessness appeal anyway, as in the JR. Judicial review, forgive me. But in fact, in Norton, there's a mention by, trying to find the passage. There's in fact a mention that would have made no difference to Mr. Norton. Forgive me. Yes, at page 655. Paragraph 58, the assertion of Lord Justice Mayles. In the event it is clear that the appellant was aware, well within the 2-year period, which has not yet expired, of the effect of section 195A. Nevertheless, however technical this may be, Parliament has stipulated that if the local authority's housing duty to a person in priority need is to cease by virtue of a PRSO, the offer must comply with section 1937AA and 7AB little c.
So just talking around this for a moment, if this were an ordinary judicial review, then before the amendment to the Senior Courts Act, potentially a court would have declined to grant any relief if it could be seen that the result would inevitably have been the same. The Senior Courts Act was then amended so that the court could decline to grant relief if the result would have been highly likely to be the same, or something like that. You say this is different, there's a statutory condition that has to be satisfied. If you don't satisfy it, that's that. That's your case.
Yes. Yes. And unless I can assist you any further, those are my submissions. What? I'm also my learning friend to draw the court's attention to 48C.
So presumably the point that Mr. Calzavara is making is that the point was conceded.
Oh, I see. Yes.
I see.
I see. Well, I say it's partly conceded.
Yes. Which is, thank you very much. So thank you all very much, both those who've had speaking roles and those behind them, for very helpful submissions. You will not be surprised to know that we will be reserving our judgments in accordance with what is now the practice. They will be delivered remotely rather than by anyone attending in court. You will obviously be provided with drafts in advance. Those drafts will go to those who have been identified in the forms that you've helpfully filled in. I'm sure you have well in mind the Court of Appeal's remarks in the Counsel General for Wales case about the importance of maintaining the confidentiality, so I mentioned that again. We would hope that in the light of our judgments, you can agree orders dealing with consequential matters. If there are points on which you disagree, we'd be grateful, please, for brief written submissions, and we would expect to settle the points in the orders that we make. But thank you all again very much. All right.